Well, good morning to all. Welcome to a new court year. I especially want to welcome all of our new law clerks, interns, and staff that have joined us over the past year. A lot has changed in a year, including having lost my predecessor, Chief Justice Ralph Gantz, unexpectedly and way too soon. Given his love of baseball, I can think of no more appropriate way to honor him than to use a baseball analogy as we start today. As Chief Justice Gantz would say, for those of you who said wait until next year, well, next year is finally here. And therefore, anything is possible. With that, I'll ask Clerk Keneally to throw out the first pitch.
SJC-13089, Russell Berry v. Commerce Insurance Company.
Okay, Attorney Darling.
Good morning, Madam Chief Justice and Associate Justices. I'm Attorney Mark Darling. I represent the Commerce Insurance Company. I'd like to start by acknowledging the honor of being leadoff hitter today. So. Very good. This case comes before the court because you took it sua sponte from the appeals court, where it had been appealed from a summary judgment decision of the trial court. The underlying case was a declaratory judgment action concerning whether or not Mr. Sheehan, who is insured by the Commerce Insurance Company, is entitled to immunity under the Massachusetts Tort Claims Act. The underlying facts I'll just go over quickly because I'm sure you've all read the briefs and there was really very little disagreement about them. But what happened was on June 17th of 2017, there was a firearms training session in the town of Raynham run by Mr. Sheehan and attended by Russell Berry, the plaintiff in this case, as well as a number of other officers. During the day, they did firearms training with their handguns and with rifles and some new equipment they had. They broke for lunch late in the morning. During the lunch break, Mr. Berry stayed at the firearms range, which is on town property in the town of Raynham. They have their own firearms training site where they keep tools and such for the actual training. They have an armory at the station where they keep the guns and ammunition and other dangerous material that needs to be secured. During the lunch break, Mr. Berry stayed with the equipment along with a couple of other officers. Most of the other men left and got sandwiches at a local store. That included Mr. Sheehan and another officer who was running the training. Mr. Sheehan and the other officer were gone from the site for about 10 minutes and then came back to the location with the
Isn't that the crucial fact, Mr. Darling, as far as the going and coming rule, and to sort of cut to the chase? Is that going to apply, the exception going to apply beyond workers' compensation cases?
The accident, which I was about to get to, happened on town property. So I believe the line of cases that excludes the application of the going and coming rule from accidents which happen involving employees on their employer's premises as they arrive or leave from work is going to apply to exclude any going and coming analysis from your consideration here. Because what happened here is as Mr. Sheehan was parking his truck, he struck Mr. Berry, who was seated on a bench. There's really no dispute that this all happened at the firing range, town property, the place where they were doing the training. So it's on the job site. So
it seems to me, counsel, that your case rises and falls on how broadly we define the conduct at issue. And so I'm trying to get some sense from you of what the proper definition of the conduct is. You say we don't focus on the tortious conduct, the gross negligence in the parking, as you call it, but rather on what Officer Sheehan was there for. What is your best case for that proposition, that we look at the totality of what he's doing there as opposed to the what was called horseplay below?
Yes, to address that directly, no employer hires employees to commit torts, at least good employers don't. And Mr. Sheehan wasn't expected to have an accident that day. This was an accident. The Massachusetts Tort Claims Act acknowledges that employees, it was enacted because employees of public employers have accidents. And the enactment of the statute was designed to give people injured in those accidents a remedy which had, before the enactment of the Tort Claims Act, been prohibited. And so in doing so, the legislature created immunity for the public employee involved in the tortious conduct. The analysis that the court is faced with in this case is that there was an accident, and although you call it horseplay, it's really just an accident. Accidents happen.
Are you accepting it's horseplay? Because that seems to be a big factual issue. If he just came in hot too fast, that's one thing. If he tried to scare him, that seems to be a different thing. And I can't tell if that's a factual dispute or not. And I can't tell if you can hear me out of this mask, but yeah.
I know that gloss was put on it by counsel in their briefing. But the facts, as you'll find them in the agreed facts that were the summary judgment record, don't call this horseplay. They don't establish that there was anything more than an accident that happened.
Is that a material disputed fact that may matter here?
I think it's a dispute over verbiage, Your Honors.
Well, but
I think it's what you call it rather than what happened.
I mean, horseplay is, you're doing some, horseplay is clearly not part of work. Driving too fast into a parking lot may be part of work, right? Doesn't that matter?
I don't think so, Judge. I'd I'd refer you to the Monahan case, which involved a grievous injury to a firefighter, where there were counts for reckless behavior by the town and other public employees. And this is not a 258 case so much as a claim under the firefighters and statute. But in that case, the court prohibited claims against co-employees of the firefighter or other town members, even if the conduct had been viewed as reckless, because the statute prohibits the injured employee from suing his co-employees.
And does that statute apply to police officers?
Yes.
It does.
Chapter 111, Chapter 41, Section 111.
So even if they're doing something that is criminal or close to criminal?
Apply if it were criminal, Your Honor.
But it would if it were reckless.
It's a tort or other wrongful conduct. That's the language in the.
Well, other wrongful conduct could actually be something criminal, couldn't it?
That I would concede wrongful conduct gets to be vague.
But that's the workers' comp, 4111F.
Well, actually, that's in the Tort Claims Act, Your Honor, Section 2.
So the reckless conduct is found within the scope of employment under the immunity statute as opposed to 41111F. Because 41111F is the workers' comp equivalent, right? Yes, it definitely is.
Section 111F of the firefighter statute, which is its common name, was enacted to close a gap in the workers' comp statute, which was
right. But I'm trying to. It's very different to include. I mean, it may be different to include coverage under workers' comp or 41111F versus scope of employment for immunity purposes. Those may be two different questions. I'm just trying to, when you say the Moynihan case, was that a 41111F case or is that a scope of immunity case?
It actually, both issues arise in that case, Judge. Mm-hmm. But it was a 111F case to begin with. And then there were motions to dismiss other counts because they were brought against co-employees.
Mr. Dowling, can I get you back to tortious conduct for a second? And I think Justice Wengland hit it on the head when it says it depends on how we define conduct in this case. Apply the third Wang factor. If we look at conduct as for him going out to lunch, having a working lunch, that certainly serves the interests of the employer, but driving too fast into the parking lot arguably doesn't. So how do you reconcile our definition of tortious conduct and that third weighing factor?
The third weighing factor being the requirement that the employee's actions be in some way motivated by desire to serve the employer.
Right.
Well, what's happening when Mr. Sheehan comes back to the site with a sandwich is, first of all, he's bringing another employee with him, is the other fellow who was running the show with him. He's driving his personal vehicle because they used it to bring the armory, the equipment from the armory to the site. He's bringing sandwiches back during the lunch hour, which is a working lunch.
Mr. Darling, I'm sorry. So those are all things that absolutely serve the employer, but to focus in on the actual
Coming in hot.
coming in hot. Let's focus on that one.
What I was about to say is that the one thing that doesn't fit is the fact that there was an accident as he did this. I am not arguing to the court that driving too fast on the parking lot and causing this accident somehow served the employer. But that's not the issue in the case. Accidents happen. When public employees operate their automobiles. The statute creates immunity for them in the circumstances presented in this case. The remedy would be, of the injured party, would be to sue the public employer. Mr. Berry can't do that in this case because he took Section 111F benefits instead and is foreclosed from that. But if it hadn't been Mr. Berry who was injured and it was some person who didn't qualify for Section 111F benefits, I submit that the immunity doctrine would prohibit the claim against Mr. Sheehan, but would permit it against the town of Raynham.
But
But those are the facts.
but the scope of employment issue at some point merges with the going and coming rule and what he's actually doing. If you're a truck driver and you're drunk and you're texting when you go through the red light at the corner of Main and Elm, the truck company is on the hook for that under vicarious liability. It doesn't matter that the truck driver was texting or drunk or speeding or didn't see the red light. But here, the police officer is not at the range. The police officer is not on patrol. The police officer is coming back from lunch. He hasn't arrived back from lunch yet, and he's driving, however we want to define it. And so it's not so easy to differentiate scope of employment from the particular circumstances here and what's going on at this moment as he's coming back from lunch.
Yes, Your Honor. I would steer you back to the line of cases I've already mentioned on the going and coming rule. When the accident happens on the employer's premises, whether it's parking or leaving, there's a series of cases which are cited in our brief in which the court has consistently held that the going and coming rule doesn't apply.
Are those workers' comp cases or are those Tort Claims Act cases?
They're all workers' comp cases.
Okay, and this is not a workers' comp case.
Well, this is a workers' comp case in the sense.
Well, we're talking about the applicability of the Tort Claims Act.
Right.
And the state has decided to give up its sovereign immunity to a limited extent. And so you have different policy considerations than you do with workers' comp.
I agree. I would point out that in enacting the workers' comp, not the workers' comp, the Tort Claims Act, and establishing immunity, the legislature used the words scope of employment. That's almost the exact same language used in the Workers' Comp Act.
Except it's not, right? Workers' comp says arising out of and in the course of employment, right?
In the course of.
So in the course of employment seems to be different than scope of employment. And these words matter, right?
Words matter. And I would submit that in the course of and in the scope of, I can't see a difference in meaning, Your Honor. For a long time, I've anticipated this question. I cannot understand a difference in the meaning of the word course versus scope in the circumstances of the two statutes. I think it is a matter of them trying to address exactly the same issue in the same manner. They just use different words.
But they're being used in different contexts, right? Because workers' comp, we want to provide extremely broad protection, right? We've got an injured worker.
Right.
Scope of immunity is a little different.
This court has also held that the scope of immunity should be construed broadly, and you've rejected narrow constructions of the statute, Judge.
But in a sense, it's limiting recovery while the other one is providing recovery. So they're
Correct.
mirror images of each other. Yeah.
In the, I get the names of the cases mixed up. It's close. The Mangano case, which was a workers' comp case involving a ambitious employee at a Papagino's who got involved in a parking lot accident later in the day, having visited the site. This court indicated by saying, first, we state that the co-employee immunity rule under Chapter 152 of the Workers' Comp Act involves the same course of employment standard that determines whether or not an employee is acting in the course of his employment and thus entitled to workers' comp. So in the workers' comp field, the court has already decided that the course of employment that entitles you to benefits is the same standard that applies to the immunity a co-employee enjoys.
Not based on the sentence you just read, because the sentence you just read was all about workers' comp recovery, wasn't it? It wasn't.
It was.
Yeah,
but the court has also imported the workers' comp analysis to analysis of the liabilities that arise under Chapter 41, Section 111F, when policemen and firemen are injured. The same sort of analysis goes there. And I submit that it makes eminent sense to use the same analysis with respect to the immunity doctrines under the Tort Claims Act.
But haven't we already decided that issue in the Klickner case? In Klickner, we decided, in fact, not to have the same scope in workers' comp vis-a-vis the tort liability. I mean, it says specifically this, meaning the workers' comp case that you cite to, Wormstead, involved workers' compensation analysis, not imputed tort liability under respondent superior principles. So we distinguish the two.
Your Honor, you're absolutely correct about that. And that is the very reason I believe the court took this case sua sponte, to resolve the difference between the finding in the Klickner case and the finding in the Monahan case that I just read from. I see those two issues as being inconsistent because you use the workers' comp analysis broadly, but when you get to Klickner, you use the Wang analysis. And as you noticed from our brief, we followed your lead there and you did the Wang analysis at some length. I would submit that even under the Wang analysis, the immunity doctrine should apply to protect Mr. Sheehan. But
does anyone have any further questions?
No, thanks.
Okay, thank you so much, Attorney Darnell.
Just end by suggesting, Your Honor, that what's happened in this case has resulted in Mr. Berry and Officer Sheehan being treated differently. I think that is the wrong result in this case, given the fact that they're in exactly the same circumstances. Both men are working, they're within the scope of their employment, they're on the public employer's job site. They're both on their lunch hour. They're both getting paid time and a half under the overtime pay scale that they're doing that day for exactly the same work. And the only difference is that Mr. Sheehan was driving and parking when the accident happened.
Okay, Mr. Darling, we got it.
Okay.
Thank you. Okay, Attorney Cloutier.
Good morning. May it please the court, Claudine Cloutier on behalf of the appellee Russell Berry. In this case, the decision of the trial court should be affirmed because Officer Sheehan's conduct at the time of the tortious conduct in no way was in furtherance of the Raynham Police Department's goals and purposes, and in no way was conduct that he was hired to perform. So under the three prongs of the Wang test that both my brother and I have argued, he fails to establish prong 1 and prong 3. We concede that prong 2, whether or not the conduct was within the authorized time and space limits, is a bit of a jump ball. However, what is missing from my brother's analysis is what was the actual conduct that caused the injury. It wasn't simply driving into the parking lot too fast. It went beyond that. In accordance with the information in the record and the undisputed facts, not only did Officer Sheehan come into the parking lot too fast, spinning rock and gravel, he then drove his vehicle on the other side of the Connex trailer, not on the access road. He then stopped his vehicle. And in the report, the record appendix of this case, this is a fact that is not in dispute. While operating his Ford F-150 pickup truck, this is at page 60 of the appendix, Officer Sheehan pulled into the range, stopped, and then sped up, spinning rocks and gravel. Officer Sheehan's truck then turned and headed into the plaintiff's direction. The plaintiff heard the truck sliding and then impact. That, although my brother disputes the term horseplay, the term fits for this behavior.
But counsel, even if it does, is that of any legal significance? That it was just that, as counsel said, that whether it was negligence or gross negligence, it was an accident.
It is, Your Honor, because in all the cases that have found that the conduct of the public employee was either grossly negligent or reckless or perhaps even criminal, there still has to be a nexus between that conduct and the furtherance of the employer's interest.
So now let's go backwards one domino then, because I know that you're all parsing this out, splitting all of these different things. But the totality of this was, it was a mandatory training of the town for all of their police officers, and the defendant was the instructor. They were all coming there to be trained. So in the zoomed out view of all of this, aren't all of these actions when they were being paid for lunch, so the town knew that they were going to have lunch during the course of this day? Certainly you could infer that there weren't any lunch facilities there unless people brought lunch with them, that this is all part of the training.
I would agree with Your Honor. That is the context, and that's what my brother has focused on. That is the context, and I think that's part B of the Wang test. But there's two other prongs to that test, and that is the conduct that he's engaging in, specifically the tortious conduct, still has to be in furtherance of the employer's interest. In this case, the conduct he was engaging in was actually conduct he was hired to prevent, this recklessness in the parking lot. When dealing with issues of tort immunity, I don't think we can separate the actual tortious conduct from the context and the circumstances.
I guess what I'm struggling with is that's getting really granular. And I'm just wondering if we have to go that granular in our analysis, or don't we just say he's there to train them? It's lunch hour. They're being paid. He's going out to get lunch and he's coming back from getting lunch. And all of that is in furtherance of finishing the day's training and certification for the other officers. So the fact that he comes in hot and does all of this, what's been described as horseplay by the trial judge, why does that matter?
I think you do have to get that granular, Your Honor, when you're dealing with issues of tort immunity, particularly for public employees. The Klickner case did hold that the statute, Chapter 258, should not be construed so broadly as to deter people from public office, but it also held that it should not be construed so narrowly. I'm sorry, so I'm mixing my broadly and narrowly, but it also indicated that it should not be construed so broadly as to provide a cloak of immunity for public employees who are entrusted with oftentimes great authority for any reckless conduct which bears no nexus between what they were hired to do and the interest of the public employer and the actual tortious conduct.
I think that brings us back to the question that I had started with, which is how broadly do we look at the conduct?
Well, I think, Your Honor, under the Wang analysis, and I go back to the Wang analysis because although the court has looked to Wormstead for some instruction, it becomes problematic because although it's instructive, there was no tortious behavior to look at or analyze. Wormstead was strictly in Chapter 41.
Right. So let's get back to my question. How do we define the conduct? Is it as broad as Justice Georgia suggests, that this is a firearm training, lunch is paid for, officers are on call for emergencies, or large scale emergencies? If I look at it that way, it sounds like it's within the scope of employment. But if I look at it more narrowly, as you're suggesting, then it looks like it's horseplay and nobody's hired to, rev up their engine and drive fastly at somebody.
I think actually the three prongs of the weighing test speak to that issue, Your Honor. Whereas I would submit that the weighing prongs really boil down to three things: conduct, context, and purpose. The first one, whether conduct is the kind the employee was hired to perform. That's the conduct. We would submit that the conduct that the employee was engaged at the time of the tort was not what he was hired to perform.
Well, counsel, sorry, I think you're skipping the question. The question is how broadly to define that conduct.
I think part two is really context. I think most of what Justice George was hitting on were things that are the context. Is it in the scope, authorized time, space limits? They were on lunch, they were getting paid. Those are factors to be considered, but those aren't the only factors to be considered. In any tort analysis, particularly on a topic of immunity, you have to look granularly at the conduct. And I was
the problem with that is that employers, as counsel said, don't hire people to commit torts. So if we have someone who's plowing the roads in a snowstorm and they clip another vehicle, the Department of Transportation did not hire the plow driver to clip another vehicle, correct?
But they did hire them to plow the road. And in that case, he was in the exercise of doing something that was in furtherance of the employer.
Well, and that's the same thing.
That's number three, though. That's, yeah. I might be with you on number three, but I think number one is
and I understand your point. There's sort of an overlapping of the three prongs, and how granular do you get? I think in any of these situations, they are fact driven. And in here, it's really the fact of the conduct that turns this case so that.
How do we distinguish this case from my analogy about the plow driver?
So in the plow driver's case, his specific conduct was conduct he was hired to perform. He was plowing the road, and it was in the furtherance of his employer's interest in clearing the road. And the same can be true in reckless driving cases involving police chases. There are cases that hold that a police officer that drives recklessly in the course of a police chase is still in the furtherance.
What about the plow driver who is plowing the road and then decides, this is a great area here to practice my infinity signs or eights or circle eights, whatever they are, and loses control after he takes a little, excites himself because it's been a boring morning?
And I think that's a great question, Your Honor, because I think you do have to get that granular on these tort analyses. If the plow driver is doing figure eights in no furtherance of his employer's interest, and that's not what he's been hired to perform, then I think that falls within the scope of, that falls beyond.
So is it really a question of we're looking not just at the course of or the scope of or what they're doing, but question how they're doing it? Because certainly driving in and all that was not a problem, but it was how he drove in and how he handled the car.
And I think, Your Honor, Officer Sheehan would have a better, or Commerce would have a better argument if in that initial turn to the driveway is when he struck Officer Berry, but that's not what happened. Factually, not only did he come in hot, he then drove in a place where vehicles don't usually go, spun his tires and speeding up more, lost control and hit Officer Berry. I don't think that we can tag municipalities with liability.
Now, are any of these facts disputed, or do you have all your facts in the record?
Those facts are all in the record.
All right.
But that's, I think, why this case turns on the facts. It raises a lot of interesting legal issues in terms of a Wormstead analysis versus weighing analysis, and the difference between Chapter 152 versus the corresponding 111F to 258 Section 2. And I would suggest that the language in the statutes are different and the purposes and the histories of the statutes are different. But ultimately, it turns on the fact, as any analysis of tort immunity has to.
But that's why I'm bothered by the horseplay thing, just to end on. So Justice Gaziano's hypothetical, which is a good one, they're plowing the road and his supervisor is standing by the side of the road, and he just speeds up to wave at him, I take it he's still doing his job, right? But if he speeds up to shoot snow at him and scare him, that's different, right?
Precisely, Your Honor.
So is this case the first one or the second one?
This case is the second one.
But do we know that? Because it seems like that does seem to be what it's about. But when the judge adds horseplay to it, then I'm starting to think he's decided it's the second one, but isn't that the jury's call?
I don't think the term horseplay is what's dispositive here. I think Officer Sheehan's description of his own behavior is telling, in that he wasn't simply speeding into the parking lot because he was late for the next lesson or speeding into the parking lot just to get to his parking spot. He admits that he sped into the parking lot, spun rocks and gravel, drove into a place that was not the access road.
But he drives into a place that's closer to where they're eating, right?
Right.
So he arguably he's accelerating the process so that they can return to work, right? I mean, he's not parking in the parking lot because, I mean, I don't know. I'm not the jury, but I'm just trying to get a sense of, is it this granular and it's this much a totality of the circumstances test that we have to resolve these little differentials?
I think that's correct, Your Honor. But in this record.
But then you lose, don't you?
No, because the record here establishes not just that he sped into the parking lot, but he drove where vehicles don't usually go, close where people were sitting.
Closer to where they're eating, which may make sense if you want to get back to shooting.
No, then he stops. Then he speeds up again at such a rate that he essentially loses control of the vehicle and strikes Officer Berry. That's not simply, I was driving in too fast when I was intending to park.
That's definitely in the hypothetical about the snowplow trying to scare his supervisor.
Right. We don't have anything in the record to suggest that Officer Sheehan was trying to scare them. Although, as my brother's brief recognizes, I think he termed it as joking around. There's nothing about this that suggests Officer Sheehan's goal. And Officer Sheehan admitted that what he was doing was not in the furtherance of the Raynham Police Department's purpose or interest at the time of the incident. He did say that obviously he didn't strike Officer Berry intentionally, but there was nothing about his conduct that actually gave rise to the injury that should be encompassed by a cloak of immunity provided by Chapter 258. Certainly, we have public employees who are entrusted oftentimes with tremendous amounts of authority. And if we were to give them immunity for tortious conduct that has no nexus to the goals of the public employer, I think that's a dangerous precedent. And I think you have to get granular and look at what was the conduct, what was the context of that conduct, and also, was it motivated by a purpose to serve the employer's interest? And here I would say that while I agree with Justice George that the context, the time and space limits is close because he was coming back from lunch. It was a paid lunch. I think both prong A and C fail here under the Wayne test. And I would just go on to state that the Wormstead case, I think, again, is instructive, but where it falls apart and it's in our ability to apply it here is that the court in Wormstead had no tortious conduct to analyze. It was simply looking at whether or not Wormstead, in bringing papers back to the police department from a paid lunch break and returning back to the station, was acting in furtherance of or in the performance of his duty under Chapter 41. And they found that he was rear-ended at a traffic light. So there was no analysis of what actually was he doing at the time he committed the behavior. There's no immunity analysis. That I think I can yield unless there are any other questions.
Okay, thank you so much.